My Lord, I'm terribly sorry that I'm still standing.
Yeah.
With the benefit of having access to a computer with my notes on it, there's just a couple of references I must give you.
Yes.
I repeatedly said I would show you AM Afghanistan as an example of where a retrospective looking back at a hearing and saying, well, it was all fine, despite subsequent awareness of a lack of capacity or learning difficulties, is a dangerous approach at the very least, and that's paragraphs 10 to 12 and 15 of RM Afghanistan. 10 to 12 concerns the first tier tribunal. The same error was repeated by the upper tribunal.
So 10 to 12.
That's page 184, the bundle. And you actually see the passage cited there from the first tier judge at paragraph 11, having been a psychological report having been drawn to his attention which identified certain learning difficulties.
Yes.
And effectively what the court goes on to say is, well, that doesn't deal with the content of the report, the reasons why and what the learning difficulties mean in practice. And paragraph 16 effectively says the upper tribunal, in approving the first tier tribunal's approach, made the same error. So I said I would give you those references, and now you have them. The second point is just to clarify something I said, because I want to make sure I'm absolutely accurate. When I was dealing with exceptional circumstances in Ladd versus Marshall as arising from the case of E, and I mentioned the Hiley case, which was deemed to be an exceptional circumstances case, even though there had been a failure by the solicitors to obtain the relevant evidence. At paragraph 83 of E, which is at page 141, I just want to be absolutely clear what the Court of Appeal said about that, so I'm not misleading anybody. The first sentence, case decided on its own unusual facts, well, that applies as the court subsequently find to all these cases where Ladd versus Marshall principles weren't applied strictly. We do not treat it as establishing any general proposition as to how the discretion should be exercised, nor with respect do we see it as supporting any general departure, even in asylum cases, from the effect of the decision in ex parte al-Madawi. As regards failures of the parties' advisors, although we have not heard detailed argument on this aspect, I just want to clarify that the decision in el-Madawi in that principle concerned circumstances where the legal advisors have clearly been negligent, not with a situation where there may have been some failure by the legal advisors, but something falling short of negligence.
Yeah.
And then just finally, tab 11 contains a case called Hussain. It's a decision of the Court of Appeal. The leading judgment is given by Lord Justice Bean. And in particular, in response to some of the questions asked by my Lord Justice Stuart-Smith, there, Lord Justice Bean, in the context of this tribunal, Social Entitlement Tribunal, didn't consider it necessary to apply the error of law approach at all, but simply applied a Ladd versus Marshall approach to new medical evidence, not about capacity, about the substantive issues. Now, I have to say that there's no engagement with E in that case, but it does post-date E. But it's certainly an example, at least, of the Court of Appeal being satisfied to approach the issue in that way. And as I understand it, although you don't have them, that case has actually been followed by a number of other upper tribunal decisions where a similar approach has been taken to material evidence that only arises after the event, as an exception to the principle that on an appeal you should only look at the material that was before the decision maker. Complex it makes the picture slightly more complex, I accept that, because it just demonstrates there's a lack of real clarity about how the approach should be in the tribunal. But it's important I should just highlight that case because it's in your authorities.
And which paragraphs in
23 and 24 at page 164.
23 and 24. Thank you.
And this is about fresh evidence in the upper tribunal on appeal from the first tier tribunal.
Indeed.
Is there anything about fresh evidence on a second appeal to hear our approach to fresh evidence?
Not in the authorities bundle at the moment that I'm clear about, but my submission would be that Court of Appeal rules would apply in the normal way.
Thank you.
Even though it's a second appeal. So I definitely will sit down now unless there's anything further I can help with.
No, thank you very much. Ms. McGibbon.
Thank you, my lord. I propose to make my submissions essentially in two halves. Firstly, dealing with the issue of principle, what is the correct approach to capacity and evidence of capacity after the fact in tribunal proceedings. And then secondly, dealing with the facts of this case. And that's partly because, as my lords will have seen from my skeleton argument, my client has a position on this appeal itself. But Lambeth and indeed all other local authorities are frequent litigants in the first-tier tribunal and have a very strong interest in making sure that such guidance as might be given in my lord's judgment is encapsulates a fair and also practically workable approach. In my overarching submission, it might perhaps have been put more eloquently by my Lord Stuart-Smith before the lunch break in discussion with my learned friend, but my overarching submission on the approach to capacity is that the touchstone will always be whether the proceedings were fair. I set out at paragraph 6 of the respondent's skeleton argument a broad position on the correct approach. And the first of those principles that I set out is that litigation capacity, and by extension the question of the appointment of a litigation friend, or indeed any other adjustment as might be made to accommodate a person who lacks capacity, is ultimately a question of procedural fairness. And we can see that because it is the running theme throughout the case law, albeit that it is expressed in slightly different terms in each of the different cases. And my learned friend largely spared my lords the authorities bundle this morning, but I may be about to make up for that. Because
You may be forgiven.
I do want to go to some of those cases to see how it is expressed, but at the same time how it can be drawn together, and it ultimately boils down to that same question of fairness. And so if I could start please with Masterman list. This is, my apologies, I have tabs, so I'm
Do you have
privileged
page
in that
numbers as
respect,
well, or
but,
only tabs?
Begins at paragraph, I think it begins at page 89. No, apologies, it begins at page 75, it is my tab 8. And the page to which I want to take my lords is page 89, paragraph 31. Now, this was...
Hang on, which page are you
on? Page 89, paragraph 31. Now, note at this juncture that Masterman Lister was
Sorry,
a case...
I'm very sorry, I must have misheard. Are you looking at Masterman Lister?
Yes.
My page 79.
Apologies, my lord, I'll speak more loudly as well. It's page 89.
My mistake.
Paragraph 31.
Thank you.
And before I read it, it's just worth noting this is a case under the civil procedure rules. And so the default approach under CPR Part 21, which has been touched on this morning and which I'll return to in a little more detail, whereby a litigation friend is automatically required and the court has to approve retrospectively any step which has been taken without a litigation friend. That is the approach that applied in Masterman Lister. And at paragraph 31, what the court deals with is the approach that should be taken where it's asked to retrospectively regularise the position. And this is something that my Lord Justice Newey indicated this morning could be difficult, and it certainly can. But paragraph 31 sets out the approach. The court says, so the court can regularise the position retrospectively, and that was also possible under the rules of the Supreme Court. Continues, provided everyone has acted in good faith and there has been no manifest disadvantage to the parties subsequently found to have been a patient at the relevant time, I cannot envisage any court refusing to regularise the position. To do otherwise would be unjust and contrary to the overriding objective of the civil procedure rules, but in any given case, the ultimate decision must depend on the particular facts. In the context of litigation, rules as to capacity are designed to ensure that plaintiffs and defendants who would otherwise be at a disadvantage are properly protected, and in some cases that parties to litigation are not pestered by other parties who should to some extent be retained. However, finality in litigation is also important, and the rules as to capacity are not designed to provide a vehicle for reopening litigation which, having been apparently properly conducted, whatever the wisdom of the individual decisions in relation to it, has long been understood to be at an end. Now, that is, as I have said, in relation to the approach under the CPR, but the underlying principle and the notion of, in particular, manifest disadvantage having resulted from the lack of capacity, not a lack of capacity in its own right, being needed to reopen proceedings that have been understood to be at an end is what is required. And that has that feature in common with the approach that has been taken in the tribunals, where the default position is not that the step is invalid and needs to be regularised, but it's the other way round. So if I can take the court to C, the passage that I want to refer to is at page 171 of the authorities bundle.
Thank you.
Now, this is a case in which it was found that the tribunal had the power to appoint a litigation friend, and that's something the respondent accepts. The tribunal does have that power. But the basis for that power, we can see at the beginning of paragraph 10, the judge refers to the common law principle, the common law concept of procedural fairness demands the appointment of a litigation friend. And so, again, it's not merely by virtue of the fact that there is a lack of capacity alone. It is the fact that in the context of the particular consequences of a lack of capacity, in the case itself, procedural fairness demands that a certain step be taken. In that case, the appointment of a litigation friend. Then in AM, to which the court's been taken already this morning, page 191 of the bundle, paragraph 44. The way in which the court expresses it here is whether the adult or child would have been able to represent themselves and obtain effective access to justice without the appointment of a litigation friend. And so, again, in my submission, the touchstone there is not that lack of capacity automatically leads to the need for an appointment of a litigation friend or the need for a particular step to be taken. It is all to be judged by reference to that touchstone of fairness in the individual case. And I could go through the whole bundle of authorities and repeat that point, but I just want to highlight one other authority, which is at the very back of the...
Sorry, can I just read 44
Yes.
properly? So just looking at this first sentence, Lord Justice Ryder refers to the rare circumstances that the incapacitated adult wouldn't be able to represent himself and obtain effective access to justice without a litigation friend. Why is he thinking that's a rare circumstance? Why one might have thought that it was quite common for an incapacitated person not to be able to represent themselves and obtain effective access to justice.
In my submission, my lords, not common in the tribunal in the context of an inquisitorial jurisdiction, and the more so in the context of the social entitlement chamber, which, and I will deal with this later in my submissions, is well used to dealing with litigants in person, litigants who may have some kind of impairment, whether or not that amounts to a lack of capacity, where the tribunal is under an obligation. Its approach is to explore issues and determine them even where they're not raised by the litigants, where the tribunal has the range of case management powers that my learned friend has referred to this morning to pursue that investigative function. It's very different to adversarial litigation of the type to which Part 21 would apply. And so in my submission, it's correct to say that's not a rare circumstance, that is a rare circumstance in the context of tribunal litigation. And indeed it may be, as we see from the passage to which I took my lords in Mastham and Lister, even in adversarial proceedings, even under the CPR, it may be the case that a party has been able to have, to use the language of AM, effective access to justice, in the language of Mastham and Lister, has not been put at a manifest disadvantage, despite the fact that the court was not aware that that party lacked capacity and so couldn't take steps in response to that. It can be judged in retrospect in my submission, and where the evidence is retrospective, it has to be. The final authority to which I wish to take my lords in making good that submission that litigation capacity is really about procedural fairness is at page 379 of the bundle. I don't think that the court has been here yet, but this is presidential guidance issued in the context of the Immigration and Asylum Chamber, which sets out an approach to vulnerable parties and litigants. And I don't suggest this can be read across directly, but I go to it for two reasons. First, because if I can take my lords to paragraph 5, it can be seen that the opening of paragraph 5 indicates that the appointment of a litigation friend is a rare step, consistently with the passage to which I just took my lords in AM. It is rare in the context of the tribunals. It goes on to indicate that many litigants in the tribunals are highly vulnerable, will require case-specific reasonable adjustments in order to be able to fully participate in the proceedings. In many cases, taking steps to accommodate the vulnerabilities of a party or witness are essential, and a failure to do so may render the proceedings unfair or otherwise involve the making of an error of law. And I take my lords to that for the reference again to the touchstone of procedural fairness. And the point might be made as well that that's not a principle that engages when a party crosses the threshold whereby they're found to lack capacity. It applies equally if they're just short of that threshold and adjustments have to be made. The procedures must be fair, there must be access to justice, no manifest disadvantage. Whatever the language in my submission, it comes down to the same thing. And it may be that the very heavy focus on that threshold of litigation capacity is slightly misplaced in the context of the tribunal, because it really arises from CPR Part 21 and the default consequences of a lack of litigation capacity, which follow in proceedings under the CPR. Not to suggest that it doesn't apply or it's not a useful tool in the context of tribunal litigation, not least because there would need to be a finding of a lack of capacity before a litigation friend could ever be appointed, but simply that it isn't quite the bright line that it is under the CPR, and it may not be useful to think of it in that way because there would need to be some response or adjustment still to an impairment that fell short of a lack of capacity, and equally the response to a lack of capacity which did cross that line would not necessarily need to be the appointment of a litigation friend. So my submission will be that these other issues which arise in these proceedings, and more generally, whether a party had an impairment, whether the impairment was so significant as to give rise to a lack of capacity, whether a litigation friend should or should have been appointed, whether other adjustments were required, all of these, taking a step back, arise in the context of fairness, and the very concept of litigation capacity and the rules associated with them are one mechanism, not the only mechanism, by which courts or tribunals can seek to achieve the end of procedural fairness. That brings me to the second of the principles that I set out at paragraph 36 of the respondent's skeleton argument, having dealt with the point at 36A, the link between capacity and procedural fairness. Moving on to 36B, what does procedural fairness demand in a particular context? And as the court is aware, under the CPR, a litigation friend is required by default, but even in proceedings under the CPR, a failure to appoint a litigation friend because the court at the time did not know that the party was a protected party will not be a basis to reopen proceedings where, and I quote from the passage that I took my lords to in Masterman Lister, everyone acted in good faith and there has been no manifest disadvantage to the party subsequently found to have lacked capacity. And that is paragraph 31. And in my submission, the same essential approach applies in the tribunals. It's established in some contexts that the requirement for a litigation friend differs from the requirements under the CPR, i.e. that it is not automatic that a party who would be protected, a protected party for the purposes of Part 21, thereby requires a litigation friend in proceedings in the tribunals as a matter of procedural fairness. And I should highlight that is so even where the tribunal is aware at the time that the party lacks litigation capacity. I go to two authorities for that proposition. The first is JS, which is cited at paragraph 42 of my skeleton argument and is also at page 366 of the authorities bundle. 366, my lord. It begins at 350, but the paragraph to which I want to refer is 366. And by way of background, the issue is in JS is the circumstances in which a litigation friend should be appointed for children who are parties to proceedings in the judicial review proceedings in the Immigration and Asylum Chamber. Now, children under the CPR, anyone under 18, has a litigation friend by default under Part 21. And so that's why, although it's not dealing directly with incapacitated adults, I rely on that for the difference in approach in the tribunals. If I could take my lords to paragraph 73, at which 366. in which the upper tribunal, and this is a guidance case establishing the approach, here the upper tribunal deals with the argument that the approach to litigation friends under the CPR should also be adopted in the immigration and asylum chamber. At 73, the judgment reads, even if we thought it desirable for the relevant CPR to be adopted for the purposes of immigration judicial review proceedings, we could not do so by saying as much in a judicial decision. Cites Bravale Limited, which is not in the bundle and not relevant for today's purposes. The making of tribunal procedure rules is a matter for the Tribunal Procedure Committee and the Lord Chancellor under the TCEA, the Act, which is in the bundle. Without wishing to stray beyond our proper remit, we should make it plain that even if we had the power to make such rules, we would not do so. Despite their similarities, courts and tribunals are entrusted with delivering justice in their own respective ways, reflecting the characteristics of the parties that come before them and the nature of the disputes upon which they are required to adjudicate. That is said in the context of the immigration and asylum chamber, and I would highlight that, of course, judicial review proceedings in that chamber are far closer to civil proceedings under the CPR by virtue of being judicial review than are the kind of inquisitorial proceedings in the social entitlement chamber from which this appeal arises. But I rely in particular on paragraph 74 and the reference to the characteristics of the parties before the tribunals, the nature of the disputes, and the fact that the flexibility in procedure is a deliberate decision and not an oversight or accident.
I follow your point that this is closer to civil procedure, but should one look on to the next paragraphs?
I don't demur from the proposition that one can look to the CPR and indeed should look to the CPR as a reference point for guidance, and perhaps even that there should be reasons for departure from the approach that is taken in the CPR. And so
I mean, in the end, just looking on it, I haven't looked at this very carefully, but so they end up taking a sort of adjusted position. So children who would get litigation friends under the CPR don't necessarily.
Yes, and one of the features, I mean, there are various features that will be taken into account. And this is set out, paragraphs 84 onwards, the general guidance. There are various features that will be taken into account. The position given in the guidance is that applicants under the age of 12 will normally require a litigation friend. But one of the features that might be taken into account is, of course, lack of capacity, and one might expect that. One of the other features that will be taken into account is the involvement of a local authority in the matter. And the justification for having regard to that would appear to be that there is then a kind of authority with oversight who can raise concerns and who might raise a flag if one needed to be raised.
That obviously is in circumstances, well, I assume that's not in circumstances where the local authority is itself a litigant.
No, but it's the involvement of the local authority in a broader sense.
Yeah.
I suppose the fact that the child has come to the attention of the local authority and that they all are aware of them, they have had dealings with social workers from the local authority or so forth. Someone who might be in a position to raise it. Although there is a duty.
Is it really any more than this, that the sort of features that are potentially material to to the question of whether to appoint a litigation friend or take some other step are likely to be the same in tribunals and courts, subject to one thing, which is the nature of the tribunal, which is an inquisitorial procedure with the features that you've outlined. That's what all these cases are saying, isn't it?
Yes, they're likely to be very similar. And
so we look for procedural fairness.
Quite. And the feature which may make a difference is the nature of the tribunal and the nature of the procedure, the approach to evidence, the approach to issues.
But even in a tribunal, parties, there may not be an adversarial procedure, but they may be fighting for their lives in the same way as they may in litigation.
I don't in any way seek to
take
diminish
this
the
case.
importance.
We've got someone who's been in her house for 40 years. The impact on her of these proceedings is as great as almost anything one can imagine in litigation.
I don't for a moment seek to suggest otherwise, but it's not. That may be one reason for the approach that the tribunal takes, looking at maybe that approach is necessary in light of the fact that, as I'll return to later in my submissions, legal aid is not available. The backstop of the official solicitor is not necessarily straightforwardly available, and so because of the importance of these cases, the approach of the tribunal takes a different approach in order to ensure that it can proceed in a way that is fair to the types of litigants and the types of issues that it's faced with, notwithstanding that there is no access to legal aid, notwithstanding that most parties appear in person, notwithstanding that many parties may have some kind of impairment or mental health problem. But I would entirely accept my Lord's point that these proceedings are capable of being every bit as important for the parties who appear in them as proceedings under the CPR. The second case, leaving JS there if I may, the second case to which I go for in support of my submission that the approach in the tribunals is different and should be different to that under the CPR is the case of tendering, and this is in a social security context, albeit that the case arises in a slightly strange way, as I'll come to. That is at page 222, and the paragraph, apologies, I'm converting from tabs. It begins at page 222, and the passage I wish to take the court to is at page 235 and then page 236. Before I go there, I'll take a moment to explain the context for this decision.
It looks as though two of us need the context, but the third may not.
Yes.
No, all three, please.
Apologies, my Lord. Quite right. I will be corrected if I get the context wrong in any way.
You won't.
This was a case in which, in the underlying proceedings in the first tier tribunal, there had been an overpayment, as in this case. Proceedings were brought against a respondent AB, who was accepted at the time lacked litigation capacity. And in this judgment, the court comments on the approach that was taken to that lack of litigation capacity in the context of an issue that subsequently arose as to whether his wife, or his partner, his wife, who had assisted him in the tribunal proceedings, had been a party to those proceedings for the purposes of enforcing the order that had been made for debt against her. That's essentially I understand to be the context. But what I want to take the court to is the approach of the Court of Appeal and my Lord to the failure to appoint a litigation friend in that case. At paragraph 59, it appears that neither the I do apologise, I should start slightly above paragraph 59, because this is the passage that deals with the fact that lack of litigation capacity was established, was not disputed at the time of the proceedings before the tribunal, and that this was not a case where there was something that the tribunal was not aware of. AB had suffered a stroke in 2007, and that was the cause of lack of capacity. The tribunal was aware of this in proceedings that I think were in around 2022. This was long and well established. Against that background, I now read from paragraph 59. It appears that neither the first-tier tribunal nor the upper tribunal formally ruled on AB's litigation capacity and/or on his need for a representative or litigation friend in order for him to properly participate in the proceedings before the tribunal. The issue of litigation capacity was not, as far as we know, even investigated. In any case where there is reason to suspect a lack of litigation capacity, an investigation would and should generally be the practice. See Masterman Lister and AB v RBS. Within this litigation, before the FTT and/or the upper tribunal, CD, that's the wife of AB, was never formally appointed as AB's litigation friend. Now, at paragraph 61, the court goes on to consider what the position would be under Part 21 and the fact that a litigation friend is required, highlights the mandatory language, must. But then it goes on at paragraph 62, the top of page 236, to highlight the reasons that approach is different in the tribunals. The rules of procedure in the tribunals permit for a wider range of representatives to support protected and vulnerable parties, including but not limited to litigation friends. These rules are anchored in the overriding objective to deal with cases justly, fairly, and justly. There is no specific provision in the tribunal rules equivalent to Part 21 of the CPR. The tribunal rules concerning support for protected and vulnerable parties are applied more flexibly than in the courts. There is less formality in its processes, consistent with the quasi-inquisitorial nature and requirements of each jurisdiction, citing AM Afghanistan. The orders and reasons which have been made in the FTT and UT in this case reassure us that judges were acutely aware of the need for AB's interests to be protected and were alert for any risk that they were not. Neither the FTT nor the upper tribunal judges appear to have seen any reason to prevent CD from representing her husband, nor did they see a need to deploy their case management powers otherwise to protect the interests of AB. And so in that case, we see that the court was unconcerned, not only by the lack of any finding as to capacity, but also by the lack of any consideration given as to whether there was a need for the appointment of a litigation friend. And the reasons it gives for that are clear. And I've referred already to the deliberate reasons for the flexibility of the tribunal rules. But I would highlight here one other aspect of the approach taken by the Court of Appeal, which is the weight placed on the judgment of the specialist judges of the first-tier tribunal and also of the upper tribunal. We deal with such cases day in, day out, are well familiar with the types of issues that the litigants who appear before them might face, and will be very well placed to form a view as to the demands of procedural fairness in the context of this particular proceedings before them and the particular approach that the tribunal is adopting. And I would urge that approach on this court, that regard for the judgment of the specialist judges of the first tier tribunal and indeed of the upper tribunal. This in my submission submits the position, in my submission supports the submission made at subparagraph B of paragraph 36 of my skeleton argument, that a more flexible approach is deliberately taken in the tribunals, but that the same touchstone of procedural fairness remains, while acknowledging that the demands of fairness will be different in the context of different tribunals. Pause here while I try to read my own handwriting. Apologies.
Are you on to 36C?
I have one more submission to make
I see, yes.
in response to my learned friend before I move to paragraph 36C. The final point I wish to make, and I don't think the principle is controversial, although the its consequences in this case, or its application to facts may be, is I don't think it's in dispute that litigation capacity is specific to proceedings. But in case there is any issue as to that, if I could take the court back to Masterman Lister and to paragraph 27, which is at page 87 of the bundle. Capacity is always issue specific, but litigation is not a blanket for that purpose. If I could take the court to paragraph 27. What, however, does seem to me to be of some importance is the issue-specific nature of the test. That is to say, the requirement to consider the question of capacity in relation to the particular transaction, its nature and complexity, in respect of which the decisions as to capacity fall to be made. It is not difficult to envisage plaintiffs in personal injury actions with capacity to deal with all matters and take all lay-client decisions related to their actions, up to and including a decision whether or not to settle, but lacking capacity to decide, even with advice, how to administer a large award. And the court goes on to say that at the close of that paragraph, capacity must be approached in a common sense way, not by reference to each step in the process of litigation, but bearing in mind the basic right of any person to manage his property and affairs for himself, a right which no lawyer and no court should rush to interfere with.
While you're back on this case, it's this case that's cited as authority for the principle that you have to investigate, isn't it? If it is this case, where do we find that in the authority?
There was a reference to the in
It's in JS, the children's case.
Which I've lost.
there was a reference in tendering in the passage to which I just took the court. Tendering cites paragraph 22 of Masterman Lister in support of the proposition that paragraph 22 is at page 86.
I say paragraph 22 doesn't seem the most obvious authority for the proposition.
No, and my part of my submission is that outside the context of the CPR, this notion of the need to investigate and determine capacity as distinct from do what is necessary to ensure that the proceedings are fair is somewhat the wrong emphasis. And we see that from the fact that in tendering, although paragraph 22 of Masterman Lister was cited as authority for the proposition that there should generally be an investigation, the court was unconcerned by the fact that that hadn't taken place. In my submission, that the investigation comes, the source of the duty to investigate is really from two places. Firstly, there may be cases in which it goes to the question of procedural fairness, in which the court needs to know more in order to ensure that the proceedings before it are fair. And secondly, of course, where the CPR applies, the CPR makes its own provision for that to be investigated and for the proceedings to be on hold while that investigation takes place. But outside the context of the CPR, its position is more murky, and in my submission, the touchstone for that as well will be procedural fairness. And that's consistent with the approach to remedying a subsequent finding after the fact that that party lacked capacity. It would be strange if procedural fairness was the touchstone retrospectively, but if the court excluded that and had to make a finding where it was faced with a litigant.
It would be surprising if there was an obligation on the tribunals to investigate capacity, because actually in the tribunals capacity doesn't really matter. What matters is what is the disadvantage from which the person suffers and how should that be addressed in order to render the proceedings fair. And the whole question, investigating capacity isn't going necessarily to answer that question, is it?
My Lord Justice Edis has put it far more succinct.
That has been your position, hasn't it?
Yes, exactly. Sorry, I'm just catching up. I'm not.
I'm very grateful for that summary. That is the respondent's position, and I would add only that there may be circumstances in which one of the steps which is required is an investigation into the question of capacity and a finding and the appointment of a litigation friend. That there may be such a case, but it's not every case. And the approach in the tribunals is just as my Lord Justice Edis has expressed it. The final point I highlight on this question of the approach to capacity is having made the point, returning to paragraph 27 of Masterman Lister, that capacity is issue specific and that one needs to take a common sense approach to the extent to which that is broken down. Certainly it doesn't apply to litigation wholesale. It applies to proceedings, and there's a suggestion that common sense approach could encompass in an appropriate case, considering the particular step within the proceedings and whether there was capacity for the party to take that step, particularly in an inquisitorial jurisdiction where the tribunal may be able to take some steps that would be required in other types of litigation and fulfill that function. In that context, I go to the capacity certificate which was produced.
Are we going to need the authorities more?
We will
Yes.
be returning to the authorities, but not for a moment.
I might put them away then for a while.
This is the supplementary bundle. Now this is the first capacity certificate, not the one that has been produced in the subsequent appeal, but the one which was before Judge King in the application to set aside and before the upper tribunal subsequently, and that is at page 113. Now, the court will see at the top of that certificate, just underneath date of birth, there's a reference to the proceedings, which is said are the potential possession proceedings on her flat, 27 Frederick Crescent, SW9 6XW. Now, those, and that was the context in which the expert, Dr. Kumar, had been instructed. And I will go, my learned friend already took the court there, but I will go again to over the page to box 3.
Sorry, to page what?
Page 140, the following page,
Okay.
box 3. Now, here the expert refers to an appeal against the decision that there was an overpayment of housing benefit in the first year tribunal social entitlement chamber. So, I mean, taking that at face value, it would appear that there is at the very least some confusion on the part of Dr. Kumar as to which proceedings he's considering. And certainly, I mean, Dr. Kumar is not a lawyer, he's instructed by lawyers, but my submission would be that it appears that he may think that the appeal is related to the appeal against the decision of the first year tribunal is related to the possession proceedings, and that was perhaps also the understanding of the appellant, that the proceedings were linked in some.
Is it not fair to say they were linked in some way?
Well,
They are linked because they're currently stayed behind the
they are staged. They are staged. It's not. I don't represent the authority in those proceedings. It's not clear to me whether the entirety of the arrears is attributable to the debt in these proceedings. I would note that there was already quite substantial council tax debt in advance of these proceedings, and that is that was the subject of the.
That would have been wiped away, won't it?
Well, it's not quite that
Or
straightforward.
is it not? I see, okay.
If the court, whilst we're on the point, I'll take the court to page 6 of the authorities bundle. Page 6. That is the order that was made. It's not.
Or it's, yeah, so not the authorities bundle. The supplementary
They're
bundle.
still in the supplementary bundle. Very sorry. This is the letter.
I see, yes.
I'm not going to attempt to give evidence what the consequences of that were, but there it is.
Why are you showing us that? Apart from the fact that we need to know about it generally.
Simply in an attempt to answer my Lord's question as to the connection between the possession proceedings and the proceedings in the first year tribunal.
Okay, thank you.
For no other reason than that, for completeness. To answer my Lord's, what I think is my Lord's underlying question as to the connection between them, I entirely accept that in the appellant's, from the appellant's perspective, and perhaps from the perspective of Dr. Kumar, they were intricately linked because the subject matter was linked. It doesn't follow that they were linked for the purposes of assessing capacity, because capacity to litigate in the first-year tribunal is a different question to the capacity to litigate under the in the county court in possession proceedings governed by the CPR. And
there's no evidence that Dr. Kumar appreciated that difference. But is this a new way of putting your case? Was this how it was put before the upper tribunal?
well, I'll come to that in a moment, my lord, because the way in which the respondent's case was put before the upper tribunal was shaped by the way in which the appeal was put to the upper tribunal, and so the answer would be not quite, but that is perhaps because the point wasn't raised by the appellant in quite the same way, and I will come to that.
Yeah.
The submission is that capacity to litigate in county court possession proceedings and capacity to litigate in overpayment proceedings in the social entitlement chamber are two entirely different questions.
Why are they entirely different? I can see that you can point to distinctions between the two procedures, which would affect a litigant in different ways. But if you have features of a litigant that render them incapable of conducting one form of litigation, it's likely that there's going to be some cross-reference so that the features which make them incapable of conducting litigation A may tend to suggest that they would have difficulty at least. That's a rather long-winded way of saying your submission, which I've noted as there are not or may not be any link between possession proceedings and FTT proceedings for the purposes of capacity. That's overstating it, isn't it?
Perhaps, my lord.
Sorry, that's a very bad. I've phrased that very badly.
But submission.
My point is, you're overstating it. Or are you overstating it?
Mila has expressed myself unclearly. The submission is that they are independent in the sense that they are different questions that have to be considered separately. And
Yes.
so, of
In
course,
tribunals, the question is, what do we need to do to make this fair, given the difficulties from which the appellant suffers? In the court, the question is, does this person suffer incapacity, which is technically defined and which technical definition Dr. Kumar does address item by item. But the first question, what do we need to do to make this fair, Dr. Kumar does not address. I suppose that might be a difference.
I'm trying hard to agree with that, but again, aren't we coming back to your basic point, which is that there are points of distinction between litigation in tribunals and litigation. But to take up the cudgels with my lord for a second, the question in litigation may well be, what do we need to do to make these proceedings fair? And the same considerations may arise with different nuances in both. Anyway, I've said enough on that.
perhaps I can return to my lord's charge of having put it too highly. When I suggested that they were entirely separate, I hadn't intended to suggest by that they were unrelated in some way,
Okay.
or bore no relationship to one another. My submission is that they are distinct questions, and whilst the features of the individual that are relevant to one may very well also be relevant to the other part of the puzzle which one has to consider is what is required of that party in the context of the litigation. And so that is why one has to consider the question of capacity separately, although of course the impairment of the individual will be relevant to both. If I can try to offer a worked example, one might imagine a hypothetical case in which a party lacked capacity to litigate under the civil procedure rules because of some impairment that went to their ability to comply with pleading the requirements that their case be pleaded, or some legal complexities of the issues, or the requirement that evidence be in the particular rules of evidence. Now, if the impairment went to those features of litigation under the CPR, then it wouldn't follow that that party necessarily lacked capacity to litigate in the tribunal, where they have the support of an inquisitorial judge who is willing to consider, or who is well used to dealing with parties who may have an impairment, who is specialist in the subject matter, who is considering all of the issues, whether or not they are put before the tribunal. That may be a different question, because a party may have capacity to litigate in that context, and that may be the more so where the issue in question, or the step required of the party, is a very short and a short, straightforward step on a narrow factual issue. One can imagine that in such circumstances, a party who would lack capacity to litigate possession proceedings would nevertheless have capacity to litigate in the first-tier tribunal. And the premise for the presumption of capacity and for the principle, both under the CPR and the Mental Capacity Act, and more broadly under the common law, that one should take steps to support someone to exercise their capacity and to make decisions for themselves, unless it absolutely can't be achieved, suggests that one should not read across from the CPR context to the FTT in a blanket way an inability to litigate. One should take advantage of the fact that the first-tier tribunal does have those facilities to support someone who might lack capacity to litigate under the CPR, and if possible, put them in a position where arrange the proceedings, make decisions to manage the case such that they do have capacity. It occurs to me now that perhaps a better illustration than the one I've just given is in the judgment in Masterman Lister, which refers to even within proceedings, the possibility that a party might have capacity to take one step but not to take another. Maybe that's a better illustration of the point I'm seeking to make. That essentially is the respondent's position as to the correct approach to capacity in the tribunal. So where there is a lack of capacity, even where that is established at the time, whether a litigation friend is required will depend on whether the demands of procedural fairness in the particular case before the tribunal require the appointment of a litigation friend, and that is consistent with all of the cases on the appointment.
And just to be clear, I think you were saying earlier, in the tribunal, capacity, lack of capacity, bright line doesn't necessarily matter. The tribunal, if it thinks there is a lack of capacity, should plainly worry about it. But even short of an actual lack of capacity, the tribunal should potentially think about making adjustments or ensuring that you have a fair procedure.
Quite. The touchstone, as I said, will always be procedural fairness. The slight nuance in the tribunal, perhaps, is that, well, firstly, as the submission I've just attempted to develop, that the tribunal may be able to support a litigant to have capacity to proceed in such a way that the party before them is able to participate, for example, by seeking evidence from other parties, for example, by hearing oral evidence without in an adjusted way, in whatever way the tribunal thought appropriate. And so it may even be the case that litigation capacity is not quite as binary in the context of tribunal proceedings as it is in the under the CPR, because of that potential for a litigant to be more supported through the process and for the judge to take a more proactive role to ensuring the fairness of the proceedings and the correctness of the decision, in contrast to adversarial litigation. Where there is evidence of any kind of impairment that suggests a party is having is at a disadvantage, is struggling to participate in the proceedings, that there may be an issue as to whether they are securing, as one of the cases put it, access to justice in a meaningful way, the tribunal should always respond to that by the way in which it manages the case and by the way in which it proceeds. And that is true whether the impairment amounts to a lack of capacity or not. And that's the context in which I say that bright line doesn't carry the same significance, perhaps, that it would under the CPR. And I would add that is not merely my submission, but that is the approach to some extent that is taken in the joint presidential guidance, which refers to the need for procedural fairness as the touchstone, and then indicates that adjustments should be made on both sides of the line, and that there are rare cases in which that may entail the appointment of a litigation friend. And that may go submission as a whole may go some way to answering my Lord Justice Newey's earlier comments about the one of the cases from C in which it was suggested it was a rare occurrence that an incapacitated party could not represent themselves before a tribunal. In my submission, it is indeed rare for all those reasons, and the more rare, I would add, in the social entitlement chamber. This position is not made express in the tribunal's rules, but it is in my submission consistent with its rules on set-aside and appeal, and with its procedures. At this point, I do need to return to the authorities' bundle to take my lords to the provision for set-aside, which is at tab 6. I apologise. The rule on set-aside is Rule 37 at page 57 of the authorities' bundle. Now, it's my submission, and my learned friend may to some extent be with me on this, that this is the more appropriate procedure where there is a concern after the fact about capacity, rather than an appeal. Although I don't suggest that there can't be an appeal, and I'll come to that. But this, in my submission, is the more appropriate mechanism. Reading from Rule 37.1, the tribunal may, on the application of a party or on its own initiative, set aside a decision which disposes of proceedings or parts of such a decision, and remake the decision or the relevant part if A, the tribunal considers it is in the interest of justice to do so, and B, one or more of the conditions in paragraph 2 are satisfied. And we can see subparagraph 2D, there's a reference to some other procedural irregularity. Also a broad kind of catch-all in my submission of procedural issues which don't fall within the more narrow scope and specific scope of A to C. And so what is required is not merely a procedural irregularity, but also some consequence of that in my submission in terms of fairness, which is where the interest of justice test comes in. And that's consistent to some extent with the approach under the CPR and the passage to which I took to the court at the outset of my submissions from Masterman Lister, whereby the court won't reopen proceedings because there's found to be a lack of capacity automatically or for the sake of doing so. There must be something more. There must be, Masterman Lister, a manifest disadvantage in the tribunal rules. It must be in the interests of justice. And in my submission, that all boils down again to a question of procedural fairness. But there must be something substantive to the fairness point.
And just elaborating on that for a moment. So, if, as in this case, we assume that at the stage where there is a hearing before the first-tier tribunal, there are no alarm bells ringing, so the first-tier tribunal had no reason to do other than exactly what it did, and then later we suppose that medical evidence is produced let's say showing that the litigant lacked capacity in the Mental Capacity Act sense at the date of the hearing, that you would accept as a procedural irregularity, or not?
That would be I would consider that a procedural irregularity. Yes.
So the question then on your case would be interest of justice. The procedural irregularity hurdle would have been surmounted.
I would accept that. There would need to be something more then, along the lines of the Masterman Lister manifest disadvantage, some consequence of that lack of capacity, and that's where one looks at the interests of justice. And they're expressed differently, but my submission is that they are really, at the heart of them is the same consideration, which is whether the proceedings were fair. And so...
Can I just see if I've understood that correctly? I think this is exactly what my lord was saying. If all seems okay at the time, but, for example, medical evidence later shows that the process was unfair, you would accept that you could invoke Rule 37, 1A and 2D.
No, my lord. There's right. An important distinction.
Where have I gone wrong?
If in my submission, medical evidence alone would be difficult to see how medical evidence alone might establish that the proceedings were unfair. The medical evidence might establish that the party lacked capacity at the time of the proceedings. There would then be a distinct question where one takes the approach of looking back as to whether that lack of capacity rendered the proceedings unfair. And that is, we see that approach under the CPR in Masterman Lister. One looks back at the proceedings, one considers whether...
But doesn't it follow from the submissions you've been making that there's no hard and fast obligation first to show lack of capacity and then do a second stage enterprise? That's why I chose the phrase medical evidence shows that the process was unfair. It doesn't matter on your submissions whether it amounts to lack of capacity or not. Once it is shown that you've got a problem, the tribunal would have had, if it had appreciated it at the time, an obligation to make sure that the person could be fairly representing their position. And retrospectively may say, well, something's gone wrong here. I can invoke 37.1a and 2d and set aside.
If I understand, my lord, if medical evidence came to was provided to the tribunal, to the first tier tribunal, after the proceedings had concluded, which established that there was some impairment to the party, some, as my lord says, whether that amounted to a lack of capacity or not, potentially. And the judge, looking at that evidence and looking at what had taken place in the proceedings, concluded that the proceedings had been unfair. It's difficult to imagine a case where that judge would not also conclude that it was in the interest of justice to set aside.
I think we are ad idem, but let me give you a specific example. Let's say it all appears fine, but it became clear later that a person was going into an insulin crisis or something like that. Not picked up at the time. But let's assume that demonstrated that for half the proceedings they would have been, in normal parlance, out of it, but not recognised at the time. In those circumstances, which may be real or not, but let's pretend they're real for my benefit, 37(1)(a) and 2(d) could be invoked, whether or not there was a finding of loss of capacity. You don't need to take a two-stage.
No, there doesn't need to be at this stage. I'm not suggesting that there needs at this stage to be a consideration necessarily of that bright line of capacity. Okay. There could be a procedural irregularity. Could be that.
Maybe I think my lord is sort of suggesting that they roll together. I mean, the procedural irregularity would be unfairness, and if it was unfair, then interest of justice might not be much of a separate question.
Well, irregularity is perhaps has slightly less substance in my submission than procedural unfairness, because it could encompass something less than.
Yes.
But the interest of justice test in my submission looks at the proceedings as a whole and considers, in the way that the Masterman Lister approach does, whether there's really been any disadvantage. It looks at the thing in the round with the benefit of hindsight. So I do advocate for taking the approach of looking back, which my learned friend said was not the correct approach. In my submission, the tribunal, the court, has no choice but to look back. And that's the approach that's taken under the CPR. The court can retrospectively regularise the position. I see no reason why it should not be able to look back in a similar way under the tribunal rules. But this interest of justice test, to the extent that it ties in with the notion of overall fairness, is significant in my submission. In this case, for the reason that I will come on to, which is the finding of the specialist district tribunal judge, having reviewed the additional evidence, that the outcome would have been the same. And so one can imagine that might have been entirely different if the appellant had made the set-aside application with, for example, objective evidence in the form of bank statements from her son showing £700 payments in rent, or £700 cash being taken out consistently every month, which was something Judge King wrote to the respondent solicitors to expressly indicate might alter the balance of things, and I'll take the court to that letter. Then the tribunal might have considered it was in the interest of justice to set aside the decision. And so looking at it in the whole, but knowing what is now known about the appellant's state of mind or state of health at the time of the tribunal proceedings, and also knowing what it is that she would have sought to put before the tribunal. This court now has the benefit of the judgment of a very specialist, I think now the president of the social entitlement chamber, on that new evidence. that all has a bearing on whether the holistic question, whether the proceedings were fair and whether it's in the interest of justice to set aside the decision. My Lord Justice Newey, I think in discussion with my learned friend, raised the question, the hypothetical of a case where a party was found not to have lacked capacity, or was found to have retrospectively to have lacked capacity, but where the evidence was so overwhelming that the tribunal nevertheless felt it was in the interest of justice, it was not in the interest of justice to set aside. That perhaps a difficult to imagine in practice such a case arising, but in principle, I would adopt the premise that the tribunal judge who is looking at the application to set aside is looking at the interests of justice, and so part of that calculation of fairness and part of that judgment as to what is in the interests of justice has to be what difference would it have made? What could have been done differently? What might have been done differently? What did the tribunal not know that it might have known? And here we have the full statements that the appellant's solicitors have produced, but we don't have any documentary evidence. And so a judge finding that that evidence, had it been before the first-tier tribunal, would not have made a difference. It is, in my submission, essentially finding, in Masterman Lister terms, that there has been no manifest disadvantage. Or whether one wants to say that the proceedings were not unfair holistically, whether one wants to say that it's not in the interest of justice to set aside the decision. It comes down to the same thing of taking a step back and looking at it in the round.
I don't understand. You're founding that submission on paragraph 8 of the decision notice. That's page 110 of the core bundle. When you say that it wouldn't make any difference, but that is on the basis, and set out in paragraph 6, that he's rejecting Dr. Kumar's evidence anyway.
My Lord, this is not a question of Dr. Kumar's evidence. What paragraph 8 refers to is the substantive evidence, the witness statement from the appellant, her son, and the two neighbours.
Are you saying we should take paragraph 8 as binding us to conclude that if the evidence of which we're now aware had been in front of the first-tier tribunal in January 2021, it would inevitably have dismissed the appeal?
I might clarify my Lord's question. This is
If you're relying on paragraph 8
yes.
to say the evidence that was available by February 2022 means that it was, in the opinion of that judge, which is clearly set out, he says, not likely to lead, she's not produced any evidence likely to lead to a different outcome in the housing benefit appeal. And I'm asking you if you submit that the consequence of that is we are precluded from saying anything other than if all of this evidence had been before the first-tier tribunal in January 21, the only conclusion that we can do is that the appeal would still inevitably have been dismissed. Because I find that a very bold submission.
My Lord, I don't suggest this court is precluded. I do rely on paragraph 8 to this extent, however. What, in my submission, Judge King is is referring to in paragraph 8 is not the medical evidence.
No,
But-
I understand your point about that.
I may go to.
But you are relying. It's a fairly important plank of your submission that another first tier tribunal judge has expressed the view. I think this is done on the papers, is it?
This was on the papers.
Done on the papers, that it's not likely to lead to a different outcome. And just so that you are aware, I do not read that as precluding us from taking a view that it is at least possible that if all this evidence had gone before a first tier tribunal judge, they could and may have come to a different conclusion. If that's right, which is the position for which Mr. Burton is contending this morning, if that's right, then you have the makings of it being a material difference.
Material.
Sorry, the new evidence or the absence of the evidence being a material consequence of the fact that no one realised that she was compromised. And for my part, at the moment, all my instincts are that if that's the answer, it would be unfair to rely upon paragraph 8 as shutting out, for example, remitting back to the first tier tribunal to try it again with all the evidence that we now know about.
I don't suggest, my lords, that paragraph 8 is binding on this court, or that it precludes this court from finding otherwise. My submission, and I will seek to persuade the court of this, is that this court should place some weight on that conclusion by Judge King, not least because Judge King had the benefit of the evidence of the local authority in the underlying proceedings, and we'll come to that in more detail later.
So I'm taking you out of your course, but the difficulty here is you do by this stage have witness statements not only from the appellant but from her son and from two neighbours, is it? Now, so the judge may say, well, there's still not much more in the terms of documentary evidence, but you've got all these people saying these things in witness statements. And, who's to say when they give their evidence orally, they may be believed. I mean, they may not, who's to say? But how can you, in those circumstances, say that, dismiss the possibility of a different outcome?
Well, my lord, it is Judge King who
Well,
deals
quite,
with these
but
appeals.
in circumstances where we're not bound by what Judge King said, how can we dismiss the possibility of a different outcome when you have people seemingly willing to give evidence in support of the appellant's case?
I'll take the court to the. I haven't dealt yet at all really with
No,
the
you haven't.
facts
I know.
of this appeal, and so it may be that
Yes,
that's
perhaps you should
a question I can better
take it
answer.
in due course.
Having done so, and I will return to Judge King's decision at that juncture.
Yes.
So if I may park those
Yes.
questions until I deal with the facts of this
Yes.
appeal and the evidence of the local authority in this appeal, which is not in the bundle. Before I move on to the second half of my submissions dealing with the facts of this appeal, and I am conscious of that I didn't want to run out of time to do so, but I wanted to deal briefly with the question of an error of fact and E. And the finding in this case, which has been the cause of much argument, is the finding of the first tier tribunal that it would have been relatively straightforward for the appellant to provide evidence. That is the hook, has been the hook for the appeal to the upper tribunal and to a lesser extent to the appeal to this court. In my submission, and again, after listening to his submissions this morning, my learned friend may not disagree with me as so greatly as I'd first thought. That is not a question of capacity, but is something in a different category. It's not a question of fairness or disadvantage, or the common law duty of fairness, or the procedure the tribunal adopts. It is a finding of fact which has formed part of the, well, in my submission it's not a material part, but that a finding of that nature, that it's straightforward to provide evidence. Or Judge Hocking gives the illustration of a finding that an erroneous party finding that a party had a strong reasoning ability, and by extension the drawing of an adverse inference from that finding and the party's failure to give evidence despite the finding as to their ability to do so. That in my submission is a finding of fact to which the principles in E apply, and that is a distinct question to the question of procedural fairness with a distinct approach, the approach in E in my submission, and to the extent that the case of Hussein, which my learned friend took you to after lunch, indicates the upper tribunal departing from the approach in E. That is wrong in my submission. E establishes the approach to an error of fact, and a finding of that nature would be an error of fact to which those principles would apply. But that would need to be a finding as to which formed part of the reasoning as to a particular party's capabilities or mental state or health, mental or physical health. I highlight that distinction in part because it's relevant to the way in which the appeal has unfolded. My essential submission on that point is that there can't be an error of fact as to capacity where the first-tier tribunal has presumed capacity. There must be something more, a finding that the tribunal has made, which is said to be erroneous and which is said to fulfil the condition in E. And that is no doubt why, in this case, the appellant has focused so closely on the finding that it would have been relatively straightforward to provide evidence. So in my submission, those are two discrete issues with discrete approaches, and some of the criticism of Judge Hocking's judgment, which I'll come to, is perhaps a consequence of those having been conflated. I appreciate I've taken that overarching submission as to the correct approach a little slowly, but I hope that will enable me to be efficient in dealing with the application of those principles to the facts and to the grounds of appeal. Unless I can assist the court further on that overarching approach, which
that's helpful, and as you say, we probably need to look at the facts.
Okay, I'm grateful to my learned friend for addressing the background, and I don't want to revisit that wholesale, but I do wish to draw out a couple of particular features, if I may. As I've already indicated, the evidence that was before the tribunal is largely not in the bundle before the Court of Appeal. But what I can take the court to is tab 4 of the supplementary bundle, which starts at page 7. And I go to this for a summary of the evidence that the respondent relied on in its investigation. and in the first-tier tribunal proceedings. It sets out the background to the investigation, and for what it's worth, it confirms that it had nothing to do with the advice or the debt relief order, and how it did come about, that it was part of a project, a kind of proactive benefit forward project by the council. If I can draw the courts to the second paragraph from the bottom at page 110. I read, the appellant's son's financial footprint confirms regular rent payments to Lambeth Council. Pausing to note, Lambeth Council was, of course, the appellant's landlord, but was not the landlord who, but the appellant's son's evidence is now that he paid cash to a different landlord during that period of time. Continuing to read, he pays the TV licence, has various credit cards and bank accounts, and an account with EDF Energy, all at the appellant's property. So rent payments to the appellant's landlord, TV licence, as well as the credit cards and bank accounts that have already been referred to, an energy account for the property. Then goes on to set out the investigation and what took place. There was a visit on the 22nd of November 2017, and the respondents now criticised for not having inspected the bedrooms on that occasion. But this letter explains that once the council's officer arrived, she asked about other occupants in the 3-bedroom property and if we could look around, and the appellant became irate and asked them to leave the property. And so it is clear in my submission that they sought to look around and weren't permitted to do that. It then goes on to deal with the further evidence, and I don't read it all, but just to note, the 5th paragraph gives the date for the findings in relation to rent payments to Lambeth, TV licensing, EDF. The significance of those being, of course, those were not just those were payments for the property on an ongoing basis. So the TV license annually, but rent and energy payments more frequently than that. So that was the 1st of February 2018. So this wasn't something historic that had come up. The evidence from the appellant's son's employer, which is the court's already been taken to, that was given over the phone, and then there was written confirmation. The only point I make about the following paragraph is to note that the appellant attended with a friend, and the suggestion that she was estranged is recorded in the final sentence of that paragraph. It says, "You couldn't provide a current address, initially stating that you are estranged, and that is why you do not know where he lives. Asked by his correspondence and everything else indicates he still resides at home, and you are unable to answer this question." And so that's a record of the...
I have a slight problem with this submission, which is that the evidence upon which the tribunal relied is set out in the decision. And you've taken us to a letter which makes lots of assertions, like the son paying rent to Lambeth for years, which, as far as my memory goes, forms no part of the decision of the reasons for the FTT. I mean, I assume that the reason why you're making this submission is to persuade us that the case against the appellant was so overwhelming that whatever else was said, the first-tier tribunal was right. But I'm not sure the way that you're doing it is really open to you. My lords may disagree, but I just think it's right that I should tell you that I'm not particularly happy about it.
I'm grateful for that indication, and I don't make the submission based on my own assessment of this evidence, and where it goes ultimately is this is why I invite the court to place some weight on the judgment that was formed by Judge King, and to an extent as well the judgment that was formed by Judge Hocking, because the tribunal had a bundle of, I believe, 190 pages. I'll go to the tribunal judgment in a moment. It's clear that the judgment is an attempt to recite every single item of documentary evidence that was before it.
Yeah, but one of the trouble with being a judge is one gets judged with what one puts in one's judgments.
Quite. I would invite the court to read this in a particular context of it being a judgment of the first year tribunal. That bundle was then before Judge King and was also before Judge Hocking. And so where this goes is that it forms the basis for my submission that this court should place some weight on the judgment of Judge King, who had the benefit of the fresh evidence on which the appellant says she was unable to rely, and that resulted in unfairness, and also had the benefit of the file of documents that was become before the first year tribunal. And I don't put it more highly than that. I mean, my reliance on Judge King is in part because my submission is that I am, respectfully, the court is not in a stronger position as Judge King to form a view. That's why I go to that letter, and I apologise. My lord is unhappy.
Well, don't worry about whether I'm happy or not. My lords may not agree with me, and but it's right that I should just mention.
I accept, my lord, that not everything is referred to in the judgment, and indeed it's precisely because not everything is referred to in the judgment, although it does refer to having taken account of the entire file.
When you say the judgment, do you mean the first version or the second version, or do you mean both of them?
It's not so. Not all of the evidence, the rent payments and TV licensing and DDF are not
Not specifically identified.
Not specifically identified.
No. Yeah.
And I'm sorry. It's for that reason that I take the court to the letter.
Although at the beginning of paragraph 27 of the second version of June, there's a sentence which says, "I find that a substantial amount of evidence has been submitted by the respondent which links Mrs. Plummer's son to the property." So he does say that.
Quite, and I simply go to this letter by way of illustration that there was evidence going beyond what is expressly referenced in the judgment, and to highlight that evidence was before Judge King and before Judge Hocking and is not before this court, and that forms part of my submission that this court should place some weight on that judgment, alongside other features such as the specialist expertise and experience of the judge. That letter and the evidence set out in it formed the basis for the reassessment, and my learned friend took you through that decision. I don't propose to go back to it. It's at page 129, and that, of course, is the decision which is ultimately challenged in these proceedings. There was then an internal review, and that is behind tab 5 of the supplementary bundle, and there's a second page to this letter. I have hard copies if the court would like them. Essentially all it says is that there has been an internal review it's been reviewed by someone different, and that's the only thing I really take from the second page. And the finding is that there was overwhelming evidence linking the appellant's son to her home and no link to any other address, and that the decision has been upheld by the council on reviewing the benefit file. I don't know if my lords would like a complete copy of that letter for.
I don't know if it's going to take us any further, to be
No.
honest. I mean, I can see a reference to overwhelming evidence at page 11.
I don't suggest it.
No.
That is a great deal further. It does explain how to appeal and the time limit for doing so, and clearly the appellant was able to understand that because she did bring an appeal, and it also refers on the first page, so that the page that my lords have, to the evidence and information requested by the fraud investigator, Pamela Ciso. And I just highlight that because that is an indication of where that had been requested from the appellant by the local authority. And that's something that the first tier tribunal did refer to as the opportunities that the authority had given for that evidence to be provided.
Yeah.
There was then, of course, the appeal, the adjournments, which my learned friend has already taken the court through. I would add only there that it was Judge Maniavara who had the in-person hearing, and so did form an impression of the appellant in person. There was some consistency there, and then of course Judge Maniavara, and I hope I'm pronouncing that correctly, who was the judge at the telephone hearing. And then the hearing finally went ahead on the 28th of January 2021. I would highlight that my learned friend took the court to the letters which dealt with the appellant's concern about the proceedings having been brought about because of the debt relief order and the assistance that she'd sought. Those, of course, were not the only handwritten letters. They are the only handwritten letters in the bundle, but there were letters which were provided to the court yesterday which did deal and set out the appellant's position and her son's position on the issue in the appeal. And that broadly remains her position. The first year tribunal did understand what her case was. It was that her son had moved out and that he hadn't told her where he was going. And in his letter, he says that was because he had come of age and wasn't required to. And so the point on which there's been inconsistency is the nature of the relationship between the appellant and her son, whether they were estranged or still in contact. And that is significant because, contrary in my submission to my learned friend's case this morning, it was addressed. Yes, other issues were addressed too in those handwritten letters, but the issue in the appeal was addressed. This brings us to the judgment of the first tier tribunal. And if I can go to the page 123 of the core bundle. The submissions I make in relation to this are not, I imagine, going to come as any great surprise, but I do highlight just a couple of points. First, at paragraph 3, there's a reference there to the bundle consisting of 191 pages, as well as the further evidence submitted by the appellant on 1st December, 21st January, 4th of January and 21st of January. And my understanding is that although that doesn't refer to all the handwritten letters by the appellant, that was because some of them had already been added to the bundle, because my understanding is that the tribunal was compiling this bundle as the case progressed. And so really, I highlight that there were the 191 pages of evidence that was considered by the tribunal. Moving then to page 125, I highlight only here, well, paragraph 17, the references to the lack of independent evidence. And this is something we see in Judge King's letter to the appellant's list as well. Essentially, the idea being that there should be evidence from some official or documentary independent source, not merely from the appellant, her son, her family and friends. That something more than that was needed. Paragraph 19, we then have a reference to the fact that all of the documentary and oral evidence has been considered, and I rely on that in support of my submission regarding the extent of the evidence being slightly greater than that which was expressly referred to in the judgment. There's then a reference to the fact that it's a substantial amount of evidence. And then at paragraph 20, this is where the tribunal does acknowledge that the appellant has been raising the issue about the link between the debt relief issue and these proceedings. And I mean, it's all that is said is that that's not an issue for the tribunal, which is correct. And that reflects the fact that, in my submission, the appellant has given the tribunal some evidence which is relevant, which does go to her position in these proceedings, and some evidence which is not, and the judge is simply indicating that conclusion, and that is not an unusual set of circumstances in the social entitlement chamber. We then move to slightly longer reasons at which begin at page 116.
I'm just conscious of the time.
Yes.
We've read these.
Yes. Well, I don't wish to labour the points I've made regarding the references to having to consider all the evidence.
Yes.
I can go to paragraphs 27 onwards, because these in my submission are really the reasons for the first tier tribunal decision of the statement of reasons, page 121 of the bundle. And I largely adopt what Judge Hocking said in his judgment in this connection. But if we look at the findings, I start from the third sentence of paragraph 27. Whilst it may be that on leaving the family home, adult children may continue to use their parents' address, what is evidence in the appeal before me is that correspondence from the appellant's son's employers and bank statements are linked to the property, and that this is the only address they have. I find it is not credible such important correspondence would go to the property if her son was not living there, and if, as initially suggested, his whereabouts were not known to her. I find that employment correspondence is of such importance it would be reasonable to conclude that the employer should have known where the appellant's son was residing. Paragraph 28, the final two sentences. All that has been provided by the appellant's son is a handwritten letter in which he says that he did not tell the appellant where he is living because he has come of age. I find that position does not sit well with the seriousness of the situation the appellant has found herself in. And then paragraph 29 refers again to the need for production of evidence from independent or official sources. And the possibilities for that. So electoral register forms, council tax bills, of course it's a requirement to register for and pay council tax at the place where you're living. Tenancy agreements, other bills addressed to her son in Streatham or Enfield. And then without labouring the point again, at paragraph 31, the reference to the fact that the evidence strongly supports the conclusion and the substantial amount of evidence at paragraph 33. In my submission, those findings are significant because what we will see is that the fresh substantive evidence, and leaving aside the fresh medical evidence, doesn't go to those findings or address the reasons for the decision. The lack of evidence from independent and official sources, and simply the weight of evidence that did link the appellant's son to her address, in the absence of any other link to any alternative address at all. I'm pausing for a moment here to see if there might be any shortcuts.
I certainly think we probably need shortcuts.
Not running out of time.
Mr. Burton needs some time to reply.
Yes. Perhaps in the interest of speed, and I won't go to the fresh evidence in the forms of the four statements, particularly as my submission is that this court should place weight on the judgment that was reached by Judge King. But I do highlight a couple of features of that, perhaps, for your notes. The first is the appellant's statements. I wish to highlight just one feature of the timing, which is that the matter of the lodger, which is relied on, entirely post-dated the tribunal proceedings and the period of the overpayment and the investigation. And so one of the points that is made is that, well, the appellant did inform the authority, I think in 2019, 2020, when a lodger briefly moved in and then moved out, but that post-dates the period of this overpayment and the findings of the first tier tribunal, which is relevant to how significant one might think that is in my submission. As to the evidence of her son, that's in the supplementary bundle behind tab 12. Just two short points to note. The first being that, again, the timing. The decision notice was 11th of October 2018, and so the court is really concerned with the period up to that date. The second address that he gives, he says he moved in September 2018. So very, very shortly before the decision notice, which is challenged, and after much of the period of the investigation. So my submission, the court is really concerned with the period in which he says he was living at the first address, which is the Streatham address. There are some odd features, perhaps, of the evidence, in that the statement says the landlord was Irene, but the letter is from a Mr. Mighton, who I understand is one of the appellant's son's friends who he was living with. But I don't labour that.
It's explained in the correspondence.
It's the son of the son.
Sorry, what's your submission on this?
I simply not taking the court to it, so that was the only feature of it that I think has any consequence at all. And then page 55, which is an exhibit, and this is the closest, this is significant perhaps because it's the closest we come to the objective documentary evidence that just Judge King and first-year tribunal Judge Maniarara repeatedly sought. It's not clear what that is, but it also relates to the second address and not to the first.
So this is Enfield.
Yes.
Yes.
Yeah. Yes. Again, I don't labour any of that, but those brief features I would have highlighted, taking the court to those statements. And so in those circumstances, the court already has, and to some extent I've already developed from my submission, that Judge King had the entire file, is a specialist judge of the social entitlement chamber, as well acquainted with the nature of the proceedings, the type of evidence that might typically be expected, the type of evidence that might have made a difference to the outcome, and also, of course, had the benefit of having listened to a recording of the hearing. So this was not a decision that was made lightly. It was there was real consideration that went into this. And in circumstances where this court does not have those advantages, I do invite the court to place significant weight on and to adopt that view formed by Judge King at paragraph 8 of the refusal to set aside, which I take as being a reference to the substantive evidence and not the medical evidence. The significance of that being that the medical evidence was really there to open the door to bring in this substantive evidence. And so by the time we get to paragraph 8, Judge King is really dealing with the alternative scenario whereby...
I think we have got this point, and I am conscious of the time.
Yeah.
So I think we need to get the remaining points.
I'll move on then to the to go very quickly to the grounds of appeal to the upper tribunal, because those are very material to the criticisms which are now made of Tribunal Judge Hocking's judgment, and that is important in the context that this court's jurisdiction is to determine whether the upper tribunal made an error of law.
I follow that. So where do we find them?
So the grounds of appeal, apologies, I'll translate from the tab to the page reference. There are two sets of grounds, but I will go to the ones that we're now concerned with, which are at page 82, tab 11. And the grounds as drafted by counsel begin at page 97. The preceding pages deal largely with delay.
Yes.
I say this is important, and that the judgment of Judge Hocking has to be read in the context of these grounds of appeal. So I perhaps invite the court to revisit those if
So which
ready.
I am conscious of the time. So where do we get the punchlines that matter for our
The
purpose?
punchline is paragraphs 1 and 4, small Roman 4.
Yeah.
Because the short point is simply that this was put to the upper tribunal as an error of fact, and the error of fact was not really a question of capacity at all, but it was, as it says in the first line of paragraph 1, the view that it would have been a relatively straightforward and simple matter to show that the appellant's son did not reside at the property, and it said that that is a mistake of fact. And then at paragraph 4, the 4 criteria in E are applied, and at small 4, that's the submission as to unfairness. The mistake as to capacity to conduct the appeal played a material part in the reasoning, as it's clear that it drew a negative inference from her failure to produce any satisfactory evidence. The conduct of the appeal and the outcome would have been different if the tribunal had been aware of the appellant's inability to conduct the case without the assistance of a representative. And so those are the grounds which Judge Hocking was dealing with. Go very quickly to the judgment of Judge Hocking, and I am aware that the court will have considered this. That is at tab 7, page 59. And I would like to go just to the context of footnote 3, which is the basis for the wider issue here. And pause to note that the fact it's in a footnote and not in the text of the judgment reflects the fact that this had been put as a mistake of fact as to the appellant's ability to provide evidence, and not as to an issue of capacity as such. Reading from the start of paragraph 12 up to where the footnote is, DP appeals on the grounds of mistake of fact in that it was not relatively straightforward and simple matter for her to provide evidence as to her son's address that had been requested once one took account of her lack of capacity, impaired cognition and paranoid belief system. Well, that was the ground before the upper tribunal. Then to footnote 3. The grounds of appeal are not quite clear here, and at points also seem to suggest the error of fact was as to DP's capacity. I'm not sure that could be right, as the FDT made no finding on capacity, impliedly relying on the presumption. To rely on capacity alone as a mistake of fact would seem to have the effect that in every case where a litigant is found to lack capacity after the event, there would be a mistake of fact amounting to unfairness. Now, in my submission, this is not an error of law. That this reflects, albeit that it's framed through the lens of the way that the grounds of appeal were put, this reflects the overarching approach that I urged on the court in the first half of my submissions, essentially that there is a difference between tribunal litigation and the CPR, and that the matters are kind of the other way round, if I can put it like that, in the under CPR.
I think we've got this point too.
I think that deals largely with ground 1, and there's probably nothing I need to draw out separately unless I can assist the court. I've dealt with it, albeit more piecemeal than I would have wanted to, and if I had time I'd draw that together. But the court has my points, and I would draw the court to paragraph 46 and 47 of my skeleton argument, and those are features of this particular case, which in my submission the court can look to for reassurance in placing weight on the judgment of Judge King as to what the implications of this fresh substantive evidence would have been, which will go to the overall question of interest of justice. Was the case there? Ground 2, did the appellant lack capacity? I can take this very briefly, and I'll wrap up my submissions on the new expert evidence, QMR2 and QMR3, and into this. The first point which I do highlight is that QMR1 and QMR2 can't be relevant. QMR2 and QMR3 can't be relevant to the question of an error of law by Judge Hocking, conceptually. And there was no error of law by Judge Hocking in my submission in his approach to the expert evidence, and I would highlight the point that I emphasise in my skeleton argument, which was that he accepted the findings of the expert. He simply scrutinised, went on to consider what the implications of those findings were for the issues that he had to decide. And of course, those issues arose in the particular context of not just litigation before the FTT, but this litigation before the FTT. And so TUI versus Griffiths doesn't assist the appellant in my submission on establishing an error of law by Deputy Upper Tribunal Judge Hocking on his approach to the expert evidence. And in the interest of speed, I was also simply draw the court's attention to B and C of paragraph 57 of my skeleton argument, which is the points regarding the scope of the certificate and what Dr. Kumar actually says in his report when read in full. And I, in the interest of speed, I won't go back to it, but it's important that he says that paragraph has to be read as a whole. He doesn't skim over it. He doesn't disagree with it, but what he does is consider it in its totality. And of course, it bears repeating that he didn't make any finding of capacity as such. What he was looking at was whether there was a finding of fact that met the criteria, in, an error of fact that met the criteria in E, and whether that error was as to the appellant's ability to give evidence. Unless I can assist, the final point, my final submission, is simply that at paragraph 61 of my skeleton argument, which is that even with the fresh evidence, the submissions that have been made regarding the implications of the substantive evidence, so the four statements, and the submission regarding the absence of an error of law in the decision of Judge Hocking in light of the grounds that were before him, still both provide a basis to dismiss the appeal. Unless I can assist the court further, and I have rather skipped ahead there. But
No, I don't detect any more questions, so thank you very much, Mr. Gibbon. Mr. Bass.
I'm conscious of the time and I don't want to test your patience any longer than I may have done this morning by taking a while. If I could just start by saying this, that the two problems I was presented with most squarely, seemed to me on reflection this morning, was could I demonstrate that the evidence was uncontentious, that the appellant lacked capacity at the material time. So implicit in that is one, a hard-edged finding of lack of capacity, and two, the timing question, and whether or not that was contentious or otherwise. It's obvious that the appellant has pursued this route to get back into the substantive issue because she was otherwise locked out by the absence of an equivalent to 21.3, which would have otherwise been the natural vehicle, or through an application to set aside under Regulation 37. But as we foreshadowed in our skeleton at paragraph 66, there is something inherently quite unsatisfactory about this approach. It's my submission, and remains my submission, that the evidence is good enough and you can apply a Ladd versus Marshall approach to Kumar number 2 if necessary in order to do that. But taking a step back and keeping in mind that one of the reasons why this case is before you as a second appeal is because there is a lack of specific authority on how this matter should be dealt with. By the matter, I mean evidence coming to light after the event that there may be a lack of capacity, or to adopt the other language used during the current proceedings and by my learned friend, or my Lord Justice Edis. There are acknowledged difficulties with processing the case. But if it's right that that's what we're really fundamentally concerned with here, if the right answer is Regulation 37, procedural regularity, of course those two major obstacles I was otherwise confronted with fall away. It's not necessary for me to demonstrate that there was some uncontentious fact about capacity, and indeed on my learned friend submissions, at least it's not necessary for me to even establish a lack of capacity. What I need to establish is the issue that really is driving this appeal and underlies all of it, that there was something unfair in light of what we know about the appellant in the proceedings below, even though there was no error by the tribunal below. And it does rather seem like we're moving to a position where Regulation 37 is the answer to that. But then it does give rise to the question, how does one approach that test of procedural irregularity? If for a moment we leave aside the possibility it needs to be capacity per se, if we leave aside for a moment that it has to be a completely uncontentious fact, then in my submission we've clearly met it in this case, because there's a clear expert report before the upper tribunal demonstrating difficulties because the conditions themselves plainly existed, whether or not they resulted in a clean finding of a lack of capacity in January 2021. And moreover, it's plain a question has at least arisen about whether or not that's had consequences for the hearing below, because as we know, and my learned friend spent a lot of time telling the court, the tribunal below has lots of flexible powers available to it to accommodate those types of difficulties. So we really end up coming back to the materiality question, ultimately. And just to be absolutely clear, we've never shied away from that. We've never tried to effectively establish this appeal by a trump card, she lacks capacity, everything falls away. What we were looking for is the proper way in circumstances where evidence such as that is contained in Dr. Kumar's report becomes available, in circumstances where, in particular, the appellant can't be criticised for that failure. If the right way is Rule 37 or not, the materiality question is pretty much the same in my submission. It's certainly not the case that it's for me to demonstrate that the conclusion of the tribunal was irrational, having regard to all the evidence before it. It's simply that there's some component of unfairness, probably linked, I'll accept, to there being some possibility, maybe even a real possibility, of a different outcome should the matter be remitted. To take the test that we've got manifest disadvantage from Master and Listerman, but as my Lord's already pointed out to my learned friend, if we're discarding the concept of capacity as being the key test, there's no obvious reason to import the Master and Listerman definition of materiality. If we use E, it's material but not necessarily decisive. If we use Ladd versus Marshall, it's just credible and relevant. And then if we use Rule 37 itself, it's just interest of justice. And in my submission, it's obvious, whichever way you look at it, that despite all the points my learned friend has made, a lot of them were really submissions about how one looks at the evidence, it is at least possible, and there's a real possibility, that if the appellant had the support that she needed, the kind of support she eventually received, she would at least have had the benefit of somebody taking instructions from her in a non-stressful environment and taking the time to do it. That evidence alone addresses quite a number of the issues that have been raised against her. Then, of course, there's the evidence of people prepared to come to court to support her. Two independent neighbours. I appreciate they're not official people, but they are people coming to give to court, prepared to come to court and swear on oath, as they say. And they sign statements of truth to that effect. And her son is prepared to do the same, and also indicates that both of the people who signed these letters saying he was living with me at this time under these terms would be prepared to do the same. It's just impossible for this court to rule out the possibility that if all of those people came into court, the tribunal judge accepted they were all giving credible, truthful evidence, that the documentary evidence, which isn't necessarily inconsistent with any of that, because what it is consistent with, is a son who's decided to use his mother's address for credit purposes, essentially. But just to test that proposition, to take the highest point against me on this, paragraph 27, Statement of Reasons, First Tier Tribunal, that it's effectively not credible that the son's address with his work would be anything other than where he's living, essentially the point, falls away immediately if you actually look at his evidence where he says, I'm keeping my mum's address for credit purposes. And of course his credit's going to be linked to his employment. It's obvious.
And one of the neighbours says that their daughter, I think, does the same thing.
Why? Now, I perfectly well appreciate, my learned friend will say, well, the notion that that was why this documentation was still linked to the address was considered by the tribunal, but wasn't considered with the benefit of live evidence from people explaining it and answering questions that might go deeper and deeper and might address some of the inconsistencies. So that alone, I suggest, is more than enough. But also, it's done without the benefit of having, how can I put it this way, the opportunity for there to be the normal toing and froing in relation to evidence, the exploration through the very hearing that a tribunal is set up to do, the inquisitorial one, to dig down into those facts. There's nothing inherent in any of this evidence which means there's nothing these people could say that would mean the result would be the same. And on the contrary, if they all come up to proof, tribunal may well find that, in fact, despite the documentary evidence, it's clear that the appellant's son wasn't living with him during the material time. And as things currently stand, she's been shut out of the possibility of advancing that case before a tribunal who's aware of the contents of Dr. Kumar's report, whether it amounts to capacity or not. And that's what we say is the irresistible fundamental premise of this appeal. And I would invite the court to use that judicial instinct about fairness in that context. It has the sense of being unfair because it is unfair. We don't know what the ultimate outcome might be if it goes back to the first-tier tribunal, but that in of itself tells us there is something unfair about the process hitherto. And for those reasons, I don't think I'm going to trouble you with any more of the law at this stage. You have my submissions on it, that they're in the skeleton. Of course, it's unfortunate that these non-welfare benefits trained solicitors didn't know how to approach the set-aside application. They didn't reference procedural irregularity. They referenced the documents not having been provided, so easily dismissed by a tribunal judge who, yes, has got expertise, I appreciate that, but on the critical question of delay, reached the contrary decision, of course, from the upper tribunal. So we need to look at that in the round. And when it comes to Judge Hocking's conclusions, just my final point really on this, is what he says is, well, this point about whether it had been relatively straightforward for the appellant to provide this information wasn't actually all that important because it wasn't a credibility finding. The judge was just weighing up, the first-tier tribunal judge was just weighing up the evidence. That, in my submission, is totally unrealistic. It's unrealistic objectively because there's no way you can look at first-tier tribunal decisions not being rejecting the appellant's evidence, which she was able to give, which is he doesn't live there. So, and if you look at it from her perspective, person who's paranoid in the first place, does this look like she's been given a fair hearing, or does it feel like she's been effectively told she's not telling the truth? And the answer to that, my submission, is obvious, and again, it speaks to the same question, why these proceedings are unfair. So, may I just ask this, is there any particular issue that occurs to my lordships that I can help with at this stage? I'd be remiss of me not to take that option. No.
I don't detect any more questions, Mr. Burton.
I'm very grateful then. If I can just turn my back for one moment. In which case, those are the submissions.
Thank you very much. Well, thank you both very much for your helpful submissions, and thank you too for Mr. Rutledge and those behind those with speaking roles for their contributions. We won't, of course, be giving judgment here and now. You'll receive the draft in the normal way for you to correct our English and typing, but not, of course, to re-argue the case. We'd be grateful if at that stage you would also seek to agree an order dealing with consequential matters. If there are points on which you can't reach agreement, can we please have brief written submissions, and we would expect to settle the points in the order that we make. Finally, although I'm sure that you're all well aware of this, I ought to remind you of the importance that is attached to the embargo. You have already helpfully provided a contact list. If you think of anybody else who you think ought to receive the draft judgments, then obviously you need to come back to us to get that blessed, rather than simply providing that person with the draft. But thank you again.
Open the door for you.